available for your questions. If during the presentation you have any questions at all, feel free to type them in the designated section to the right or email me at julie@thedoorgroup.com, and we'll answer those questions for you right away. Earlier this morning, we mailed you a link to a downloadable copy of our presentation. If you haven't received it, feel free to email me right now, and I'll send you that document right away. Before we get started, please note that this webinar and all of the accompanying materials are protected by copyright, and that the entire conference is being recorded. This presentation provides general information only and does not constitute legal advice. We recommend that you consult with legal counsel to address your specific situation. So let's get started today, and I'm hoping Linda Duffy is on the line right now. Let's introduce her. She's the president of Ethos Human Capital Solutions. Linda works with our business owners and executives to provide strategic human resources direction, develop leadership talent, and increase organizational effectiveness. We also have attorney Marla Merhab Robinson. Marla's with the law firm Merhab Robinson, Jackson, and Clarkson, where she is the partner and head of the firm's transactional department. She primarily practices in the area of corporate, mergers and acquisitions, real estate, finance, and employment law. So let's get started today, ladies. Linda, I'm hoping you can take control of our webinar today and start us off with the agenda.
All right, thanks so much, Julie. We missed you last month, so we're glad that you're back this month with us. Hi, everybody, and welcome to our webinar today. And I, too, Julie, hope that I'm the one controlling the slides, but I don't know if it's you or me, so we'll just give it a shot. Here's our agenda for today. I'm going to start off and we're going to talk about some laws that have changed some things in the state of California this year. It's always interesting to work and live in California, and there are quite a few things that have gone into effect over the last year, even as recently as last month. So we want to make sure that we share that information with you. And I'm going to take the first few things and then turn it over to Marla, and she's going to be talking about some of the case law decisions that came down and also a National Labor Relations Board decision. Just a reminder, we are not talking about collective bargaining agreements or unionized shops, so if you are subject to a CBA, all bets are off on this. So just know that going in. Some of these will apply and some will not, but you always want to make sure that you're referring back to your collective bargaining agreement if you have one in place. Okay, so let's start. Julie, I don't think I am changing these slides, so I need you to do that for me. Thank you. So let's start by talking about new protected classes. So there are 3 different assembly bills that went into effect the first of this year. The first one, AB 1660, actually expands the coverage under national origin under FEHA. So in the Foreign Employment and Housing Act, you know, there's a long list of protected classes, and this one actually expanded the national origin protection to include those individuals who sought driver's licenses or received a California ID card under the new law that allows them to go even if they are illegally in the country. So even if they cannot submit proof of lawful U.S. residency, they can still now get a driver's license or a California ID card, and this gives them protection under national origin discrimination law. So if somebody comes to you with that documentation, you cannot discriminate against them based on the fact that they provide that documentation. Now, having said that, from an I-9 standpoint, they still must provide a document from List C. So if they give that to you to satisfy the identity piece on the I-9 form, they still have to turn around and submit a Social Security card or a birth certificate or something that shows that they're eligible to work in the United States. So that doesn't change anything with regard to the I-9 requirements. The second bill, AB 1443, expanded sort of FEHA in a different way. So everyone knows that again, there's all these protected classes like race, religious creed, color, national origin, etc. Well, now what AB 1443 did was they expanded discrimination or anti-discrimination measures to cover paid interns and volunteers as well based on those FEHA protected categories. So before you could not discriminate against an employee, and now you also need to, of course, not discriminate against an unpaid intern or a volunteer as well. The third Assembly Bill, 1792, has a little bit of a different protection. It actually protects employees who are receiving public assistance in the form of Medi-Cal program. So you are prohibited as an employer from discriminating against or retaliating against employees enrolled in Medi-Cal, and you can also not disclose that enrollment to other people. So you want to make sure that you take a look at your handbooks. If there's anything on here that you want to expand in your handbook, now would be a good time to do that. The next law is AB 2053, Julie, if you could turn that slide. And this is actually an expansion of the original AB 1825 bill that requires employers in California with 50 or more employees to provide anti-harassment training to their managers and supervisors. And the requirement, if you remember, is 2 hours of interactive training every 2 years and within 6 months of the time they're hired. So AB 2053, which goes into effect, or went into effect on Jan 1, now requires that that training include training on the prevention of what they refer to as abusive conduct. And there's a long definition there of what abusive conduct is. I just titled the slide bullying because that's mostly how people would refer to it, I think. So here's sort of the issue, though. It doesn't include in the bill how to prevent the conduct. It sort of just says, here's what we think it is. It also doesn't say exactly what you have to train people on. It does say that a single act shall not constitute abusive conduct unless it's especially severe or egregious. And it's also interesting because for those of you that know this training and know harassment in general, you know, there's 4 criteria. Protected category, it has to be severe or pervasive, it has to be offensive to a reasonable person, it has to be unwelcome. Well, the bullying is a little bit different because it does not need to be related to a protected category. Okay, so that's the difference between that and harassment. The good news about all of this is even though you have to include this training in the anti-harassment training now, there is no cause of action tied to this. So an employee cannot go file a complaint against the company or file a claim or charge or whatever it's called in California for abusive conduct violations yet. You know, I got to believe that that's a slippery slope and it's coming our way, but for right now, we're in the clear. Okay, the next one is on cell phone reimbursements. There was a case that came down last year called Cochran, and it basically just clarified that California Labor Code Section 2802, it already requires employers to reimburse employees for expenses incurred at work. So through, you know, conducting their job, working at your company, if they have an expense of some kind, whether it's mileage or whatever it is, the employer is required to reimburse for that. What they said is we're basically including this, that a reasonable percentage of the employee's cell phone bill has to be reimbursed if you're asking them to use their cell phone at work. Now, this is assuming that you have a bring your own device policy and that the employee is actually using their cell phone to conduct business. You have the option, of course, of providing a company cell phone, but I know in this day and age, a lot of my clients anyway just ask their employees to use their own cell phones. So you would have to come up with whatever a reasonable percentage of the cell phone bill and reimburse them each month. Unfortunately, again, it doesn't explain how to calculate that. It doesn't say whether it extends to a portion of the cost of actually buying the phone itself. It just says that you have to reimburse a reasonable percentage. The downside on this bill, obviously, among other things, is that to show liability under Section 2802, they just have to show that they were required to use a cell phone and that they weren't reimbursed for it. They don't have to demonstrate that they actually pay the bill each month. You know, somebody else could be paying the bill. So it's not without problems, but just know going forward you're going to want to make sure that if you're asking employees to use their cell phone that you're coming up with some reasonable percentage of the bill and reimbursing them. Okay, the next bill, or the next law actually added a California Labor Code Section 2810.3, and this has to do with employers having a shared liability with labor contractors or labor providers. So I'm going to say think temp agency because that's probably going to be the most common example. So there's already sort of been this joint employer issue if you have temps from an agency, you know, that are working at your place of employment, because let's face it, for the most part, unless you have a ton of them and you have somebody from the agency on site, you're the one giving them day-to-day instruction, and so it's creating a joint liability issue already. This is sort of taking a step further to say that you now share liability with that temp agency for their wage violations and if they fail to obtain workers' comp coverage. So that's a little scary, as Marla and I were talking about over the weekend, because how do you actually know whether or not your temp agency is in compliance with wage and hour laws or if they have workers' comp coverage? So it does have some exclusions. Of course, they always go out and exclude themselves right away after they pass a bill. If you have fewer than 25 workers, including both temps and regular employees, or if you have fewer than 5 temps at a time, then you're excluded. But you definitely want to start thinking about the things that you can do to protect yourself under this bill. So a couple things you can do is obviously vet those agencies, do a little search on Google, talk to them directly, find out if they've had complaints filed against them in the past, see what you can find out there. You want to read your contracts really carefully to see if there's who's responsible for what conduct, and make sure that there's an indemnification provision in their service agreement so they're indemnifying you for their wrongful acts. So if they're not in compliance with wage and hour, they don't pay, we'll say, your employee properly, that it's not your problem, it's their problem. It also specifically says that the employer may not shift to the temp agency any legal duties or liabilities under Cal OSHA. And just as a reminder, because this changed or was reaffirmed last year, if you have temps out on your site that are injured on your premises, and if you're supervising them on a day-to-day basis, you are required to list them on your OSHA 300 log. So it's not just a temp agency, you have to list them as well on your log. Okay, and then the last thing I'm going to talk about for a few minutes is sick pay. And I know we're going to get a lot of questions about sick pay because this honestly is one of the most poorly written bills because for 2 reasons. One, just it's very confusing and there's a lack of clarity, but also because I think this is a perfect example of how people that pass the laws aren't business people necessarily and don't understand sort of the reality of what we have to do on a regular basis. So this bill, AB 1522, part of it went into effect already Jan 1, and then part of it goes into effect on July 1. It essentially requires California employers to provide a minimum of 3 days or 24 hours each year of sick pay to anyone working at least 30 days in a year. Okay? This includes part-time people. So a lot of people already offer sick pay to their full-time people, but this includes part-time people. And that year can be a rolling 12-month period, or it can be on a calendar basis as an example. Now, we already had a couple of questions come up. Julie told us as we were waiting for the webinar to start. And if the company already has a PTO policy in place that allows some of that time to be used for illness, then there's no need for a separate sick policy. You're fine. Okay, so just know if you have PTO in place and it's going to allow them to use at least 3 sick days a year, you're fine. You don't have to make any sort of change. You just want to make sure that your policy says that PTO can be used for whatever reason they want, essentially. The sick pay can be used for the employee's own illness, can be used to care for a family member, and that's actually defined in the bill. It's a long definition, but essentially child, parent, spouse, domestic partner, grandparent, grandchild, and sibling, although it's like adopted, step this, step that, so you want to go through and make sure, you have it all listed out. It can also be used to seek medical attention for injuries, due to domestic violence, sexual assault, or stalking. The other thing in the bill is that it sets reasonable increment for use as not less than 2 hours. And so if you want to have a policy that says, oh, you have to take it in a day increment, you cannot have that policy. So you have, the minimum can be 2 hours increments. Okay, on the next slide, it goes into a little bit more detail about sick pay. Sick time can either be lump sum granted or it can be accrued over time. Now, I'm going to tell you that my preference on this is pretty strong, and it's a lump sum grant, and I'm going to tell you the reasons why, but I'm going to tell you how you can handle both of it. So if you do a lump sum grant, let's say Jan 1 of each year, and give everybody 3 days, it really is that simple. You give them the 3 days, they can use it throughout the year. Once it's gone, it's gone. There's no rollover. next Jan 1 comes along and you give them another 3 days. Okay, you're compliant with the law. Where it gets, and same thing again with the PTO. Okay, now if you're accruing sick, then it's a little bit more complicated because the law says that the accrual must be no less than 1 hour of sick time for every 30 hours worked. So let's think that through, because here's the problem. Most payroll systems that I'm familiar with are not designed for this. They can't count time over multiple pay periods for one. So I've got a client, for example, that has part-time employees that may work only 5 hours a week. So it may have to go 6 weeks, before they hit that 30 hours. So you need to go back and talk to your payroll people and say, hey, is this something that you can do, count across multiple pay periods? Okay, that's one problem. A second problem is if you put them on this accrual process, and let's say your intent is to give them the 24 hours a year, the problem is if you put in the accrual, the law says very specifically it has to be no less than 1 hour of sick time for every 30 hours work. So for full-time employees, that equals about 8.67 days per year. Not 3, but 8.67 days. Now the good news is you can cap their usage at 24 hours per year. But again, with my employee relations hat on, I'll say, how difficult is it going to be to explain to employees that see on their paycheck stub or in a self-service module in a pay system that they've got 8.67 days accrued, but you're saying, oh no, but you can't use any more time because you've already used 24 hours. I just think that's going to be a really difficult conversation to have and a really difficult thing to track and manage, because essentially in this system you've got to have 2 different caps that are needed. You're going to have the accrual cap, but you're also going to have the usage cap. And again, most payroll systems are not designed that way. Exempt employees are deemed to work 40 hours per week for the purpose of this calculation, unless, of course, and this is rare, but you have an exempt employee who is specifically exempt and only working part-time. Julie, there's something on the screen if you want to take that off. The other thing is if there's accrual, then paid sick days must carry over, but you can cap it at 48 hours. But again, here's another problem. So the cap can be set at 48 hours, but remember you have that usage cap, and you can say you can only have 24 hours in a year. The problem is once people use time and it falls below that 48 hours, usually the system is designed to start accruing again. So I'm not sure how you're going to keep track of the usage cap at 24 hours if that's what you're intending to do. So for all of those reasons, that's why I'm strongly urging my clients, whenever possible, to just go with a lump sum grant. There is some downside to that, because if somebody uses it in January as an example, then all of a sudden it's like, they could leave in February and you've essentially paid them time that they wouldn't have received if you accrued it over the course of the year. But I just think from an administrative standpoint, it's going to be a lot easier this way. There's also no provision for prorating the accrual for part-time employees. So a lot of us would design policies to say, okay, if somebody's working 20 hours per week, then I'm just going to give them a grant of 12 hours of sick pay each year. And unfortunately, the law doesn't allow for that. And so that's the difficulty again. It would be so much easier if I had written this law. But anyway, not lucky that way right now. Finally, the other sort of weird part of this law is that if somebody's rehired within 1 year of leaving, you must reinstate their time. You don't need to pay out sick time when they leave. That's the good part. But if they're rehired within a year, you have to reinstate whatever available balance they had at the time that they left. A few last things on sick pay. And Julie, is there any way to get rid of that message on the screen? I think it's on your screen and not mine, but so maybe it's on. Okay.
I think it's just showing up on yours.
Okay, thank you. So on sick pay, the other thing I said, parts went into effect on Jan 1, and there's a new posting requirement. If you annually buy from Cal Chamber or somebody else all of the posters that you need, it is already included, so you don't have to worry about it. If you have old posters and you haven't updated them, because there really wasn't a big reason to do it this year, then there is a new poster that you can simply print out and post. And we're going to send that out to everybody after the webinar, so you'll get a copy of that poster. You can just literally print it out and stick it up next to the rest of your posters. The second requirement, and this is a really important one, is that this law amended Section 2810.5 of the Labor Code, and that is that wage theft notice. Some people call it notice to employees. Some people call it a 2810.5 notice. Whatever you call it, this is the notice that you have to give all non-exempt people at the time of hire and when anything on the notice changes. And it includes like what their rate of pay is, what's their base rate, their overtime rate, their double time rate, who your workers' comp carrier is, all of those different things. So again, we're going to send the template out to you, but now you have to include on that notice the sick pay provision and how it's calculated. So you'll see that on there. So that goes into or went into effect January 1st. The actual accrual or granting of sick pay doesn't have to happen until July 1st. Okay, so you've got a few months to figure out with your payroll providers how you're actually going to make that work if you're not already granting sick pay. The other thing I failed to mention on the prior slide, and this people may have a question about this, is new employees accrue from day one, but you can put a 90-day waiting period on that before they can use it. Okay, so that's one other thing. The law also says you're required to keep sick pay records for 3 years. You can't discriminate against anyone who actually uses sick time or files a complaint for noncompliance with this law, and there are penalties for noncompliance that we don't need to go into because everyone's going to be in compliance. And with that, I'm going to turn it over to Marla.
Thank you, Linda, and Happy New Year, everyone. And it is a Happy New Year. We really have, as you can see, limited changes. Many years we have a lot of changes that are really taxing on employers. This year we have limited, and some of the changes that came out of some of the case law actually is to our benefit as employers. So the first change I'm going to talk about is recovery period, and I recognize that this doesn't apply to everyone, but I have quite a few employers who do have outside workers and have had issues this last year with the heat illness prevention programs. So the California Code of Regulations mandates that all employers with outdoor places of employment, and that can be full-time you're outside or part-time you're outside, implement a heat illness prevention program that includes, among other things, providing workers cool-down periods of at least 5 minutes in the shade. This new SB 1360, which went into effect the first of this month, amends the Labor Code Section 226.7 to require employers to count as time worked that quote-unquote recovery period or 5 minutes in the shade, also known as a cool-down period. So if there was a question before, which I don't really think there was, most of my employers were already paying this time, it's clear now that this is time worked and must be paid. The next statute I'm going to talk about is AB 1710, and this went into effect in September of last year. This statute amends the Civil Code, and it increases an employer's responsibility in the event of a data breach. The statute requires the employer that owns, licenses, or maintains personal information about California residents to implement and maintain reasonable security procedures and practices that are appropriate to the nature of the information to protect the personal information from unauthorized access, destruction, use, modification, or disclosure. And of course, this is a product of all of the very newsworthy data breaches we've heard about from the very large companies. With respect to the information required to be included in the notification of a data breach, if the person or business providing the notification was the source of the breach, it requires that the person or business offer to provide appropriate identity theft prevention and mitigation services, if any, to the affected person at no cost for not less than 12 months. So this could be very expensive if you had a large breach. If the breach is exposed or may have been exposed specific personal information. And then here's a list of some examples of specific information. This is not all-inclusive, but Social Security numbers, driver's licenses, California ID numbers, bank account numbers, medical information. I would add addresses and the like. So the first court, or this is actually an administrative decision I'm going to talk about, was a decision from the National Labor Relations Board issued against a company called Purple Communications. In Purple Communications, the employer maintained an electronic communications policy which prohibited employees from, among other things, using the employer's email system to engage in activities on behalf of organizations or persons with no professional or business affiliation with the company, so non-company activity, or sending uninvited email of a personal nature. And in this case, this was a union shop. The union, which sought to represent certain of the company's employees, filed objections to some union election results, and also claimed that it was unfair labor practice, alleging that this email policy, which is similar to ones I'm sure that all of us have, restricted employees' rights to engage in protected concerted activity under Section 7 of the National Labor Relations Act. Just as a reminder, the National Labor Relations Act is the act that allows employees to talk about the terms and conditions of employment and to organize if they want. And anything that thwarts their ability to do that is generally a violation of that act. In overruling a prior case of its own, the National Labor Relations Board held that employees who have already been granted access to an employer's email system for work purposes have a presumptive right to use the email system to engage in this protected activity about the terms and conditions of their employment. And during non-working time, an employer can rebut this presumption, because it is just a presumptive right, only by demonstrating special circumstances that make a ban on non-business use of the system necessary. And the necessary has to be to maintain production or discipline among its employees, so it's a very high standard. The board recognized an email as an increasingly critical mode of communication in the workplace, stating that the modern-day pervasiveness of email has rendered it as a natural gathering place for employees to communicate with one another, including about the terms and conditions of their employment. However, the board stopped short of finding that the employer's electronic communications policy was unlawful. It just said that in this case you have to allow the employees to use it during non-working hours to speak with each other. The board stressed that its holding in this case was limited to email only and did not restrict the employer from monitoring its email, as most of us do, in furtherance of legitimate management objectives, for example, to prevent harassment. And it also does not limit the employer's ability to enact uniform and consistently enforced restraints on other prohibited uses. And again, the decision applies only to employees who have already been given access. So if you have a line employee on a manufacturing line that doesn't have access to the employer's email system, it does not require the employer to now provide them access. And the opinion makes clear that it is not meant to address non-employee access to employer email systems as well. This decision was decided on party lines and is definitely likely to be appealed. So we're going to have to watch and see. But in the meantime, you may want to take a look at your employee handbook policies and consider revisions to them. Discuss with counsel whether we want to be silent as to this issue, and be aware of what has to be allowed if it's requested, or to actually put it in policy at this time. Next is the Peabody decision, probably the one decision last year that will cause employers the most headaches this year and beyond. And hopefully we'll do a small job of getting the word out, and you can spread the word amongst your peers with respect to this, because I would guess that probably at least 50% of the employers out there right now who pay commissions are probably in violation now of wage and hour laws based on this Peabody decision. In Peabody, the plaintiff employee was a commissioned salesperson and brought a class action against the employer alleging wage and hour overtime violations. She alleged she was never paid overtime wages and occasionally made less than minimum wage when she was paid only hourly wages. The appellate court that originally heard this after the trial court said there's no controlling precedent here in California, so they sent it directly to the California Supreme Court. And the issue was, can an employer attribute commission wages paid in one pay period to other pay periods in order to satisfy California's compensation requirements? And what the employer was trying to satisfy here was that the employee was making commission wages over at least double minimum wage and over 51% of the compensation to allow the employee to be exempt from overtime. And the employer specifically was taking a monthly commission payment and applying it to 2 pay periods, because there were 2 pay periods during the month. And the court said, the California Supreme Court said, no, you can't do that. It says that the employer satisfies the minimum earnings prong found in the wage order, and in this case it was wage order number 4 for those of you who like to read the wage orders, only for those pay periods in which it actually pays the required minimum earnings of 1.5 times the minimum wage rate. The court said that this is consistent with the labor code and with the DLSE policies, and that they required the measurement of the employee's wages be done on a per pay period and a per work week basis, respectively. So you've got to look at the work week in that particular pay period to determine if the 1.5 times has been met. The major problem for employers who only pay commissions, again, is that a lot of them only pay once a month, and that's clearly going to be a violation if during the prior pay period in the same month or a later period, if the commissions are paid earlier, the employee has not received at least minimum wage or at least 1.5 times if there's overtime. The next case is Integrity Staffing Solutions versus Busk, or Busk, depending on how you read it. This is really an interesting case and very, very recent. I think it was in December it came out. It was 2 Amazon workers in Nevada who worked for Integrity Staffing Solutions, so it was a staffing company. They filed a class action and alleged violations of Fair Labor Standards Act. So their allegations were under federal statute. They alleged that at the end of each day, they were required to pass through a security clearance checkpoint where they had to remove their keys, their wallets, and belts, and then go through a metal detector and submit to being searched, which doesn't sound like much, but the problem was this is a large warehouse, so the wait was roughly 25 minutes after clocking out, and then as well, they had up to 10 minutes of their 30-minute lunch period were being consumed by security clearance and transition time similar to this. The employees alleged that the company could have reduced security screening time to a de minimis amount by adding screeners or staggering shift terminations, and that the screenings were conducted to prevent employee theft, and thus they were solely for the benefit of the employers. This case went all the way to the United States Supreme Court, and the United States Supreme Court held that the screenings were not an integral part of the workers' jobs and thus not compensable. So in order to be compensated for the time, the court said that the test there is it an integral part of the worker's job. The Supreme Court said that this particular kind of security screening was just part of the process of coming and going, and that it was simply to get out the door at the end of a shift and undeserving of extra pay, despite how much time it took. The court held that whether the activity was integral did not hinge on whether the employer required the warehouse workers to engage in that activity, which clearly they did. They required everyone to do it. They said instead it depended on whether the activity was tied to productive work and that the employees were required to perform that productive work. And clearly it wasn't. They had nothing to do with retrieving products from the warehouse shelves or packaging them for shipment. It was just with respect to theft and was unrelated to safety or efficiency of the warehouse staff. This is a really shocking case to me. I'm very surprised at the way it came down. Had it started in California, maybe it would have come out differently. Next, I'm going to talk about 2 cases with respect to arbitration. And the first is a fantastic case for employers. It came down in June of last year. The California Supreme Court announced in Askanian versus CLS Transportation that arbitration agreements with mandatory class waivers are generally enforceable while carving out one notable exception, and that exception is claims brought under the Private Attorneys General's Act, or PAGA, which is a California statute and unique to California at this time. So this is a great case for employers and should be a call to action to all employers to review your employment agreements that you're using to see, first of all, do they include arbitration language to force the employee to arbitrate employment claims other than PAGA claims, and if so, for those of you who remember years ago, do the arbitration provisions comply with Armendaris to make them enforceable, but that it have some protections for the employee, such as the employer paying all arbitration costs, and including the rules that are tied to the arbitration. And then after that, now we can add a class action waiver, which is tremendous benefit to the employer if we can get our employees to sign class action waivers. For those of you who have been in the unfortunate circumstance of being part of a class action, they're terribly expensive and the risk of liability is quite high. even if there's just a small amount of liability because of the size of the class. The second case is Ruiz versus Moss Brothers Auto. And in the Ruiz case, the plaintiff was Ernesto Ruiz, and he also filed a class action complaint alleging various state law wage and hour violations by Moss Brothers. And the company filed a petition to compel arbitration and based it on an arbitration agreement which the company claimed was signed electronically in September of 2011. And the company offered, as proof of the execution electronically, the declaration of its business manager, a woman who claimed that Mr. Ruiz electronically signed the agreement on or about September 21st, 2011, and that the same agreement was presented to all persons who thought or sought to maintain employment with Moss Brothers. And she further stated in her declaration that each employee is required to log into the company's HR system, each with his or her own unique login ID and password, to review and electronically execute the employee acknowledgement form, which included the arbitration agreement. Now, I look at this case as a case of bad lawyering and not necessarily of wrongdoing by the employer. The employee, and I'll tell you why. The employee in the case argued that the woman supervisor, Ms. Main's statement was not enough to prove that he did in fact sign the agreement. He insisted that he did not recall signing it, and that had he been presented with it, he would not have signed it. And the court concluded that the company did not present sufficient evidence to support a finding that he signed it electronically. The court noted that electronic signatures have the same legal effect as handwritten signatures. That's clear. And everybody should take that away here. Electronic signatures are still good. It's a matter of proof. And the court said, just like a handwritten signature, it must be authenticated, or secondary evidence that it was agreed to must be received in evidence. And the court found that the woman, Ms. Main, who was the supervisor who asserted his signature, never explained how his printed electronic signature or the date and time printed next to it came to appear on the agreement. So in my opinion, this is just a case of bad lawyering. The lawyers did not put enough evidence forth on how this process, the electronic process, worked. The mere declaration by the supervisor was just not enough. The court wanted to know more, like how could it have been placed on the agreement only by someone using Mr. Ruiz's unique login ID number and password, and that all the employees were required to use their unique login ID and password. That didn't get into evidence somehow. I don't know why or what happened, but to me this just seems like the lawyers didn't do their job correctly. The court stated that the decision demonstrates that even though nearly all jurisdictions recognize the legal effect of electronic signatures, employers must be able to establish that this electronic signature was the act of the employee. Now, the takeaway here is, make sure you periodically review the procedures you use to obtain electronic signatures if you're doing that, and to ensure, maybe confer with counsel that you'll be able to authenticate that signature if necessary at a later time for use in litigation. If you want to be very conservative, don't use electronics and use the handwritten. I know that doesn't work for a lot of companies, especially the tech companies. And with that, I'll turn it over for questions.
Well, thank you so much, Marla and Linda. It always starts off the new year as one of our best attended webinars, and obviously it's because everybody's interested in all these new laws, and we don't want to step on any of those HR landmines. Now we have about approximately 15 minutes for Q&A. As with everything, and we're continuously improving as well, some of you that have submitted questions may have noticed that you're already getting some responses, so we're trying to make sure that we have enough time not only to answer all your questions, but make sure you get an answer either verbally in conversation or electronically in response to the questions that you've already posted. So let's go through this real quickly. Questions, just open up your question queue, the box that's kind of over to the right. Type in your question, and I will read them aloud for either Marla or Linda to answer. Some of you also have emailed already questions to me. Again, my email address is julie@thedoorgroup.com. And because Chris, and I think we answered Chris's question already, but I have to reward someone that sent in their question at 10:30 this morning. So, ladies, we're going to start off with Chris's question. Can you please clarify, if anything, an employer who offers 3 weeks of paid PTO annually and what they have to do differently in light of the new paid sick leave requirements?
Sure, I'll take that one, and let's go through like all the different categories. Okay, so if you're currently offering PTO, you want to make sure that your policy says that it can be used for the purposes defined in this particular law. So it can be used among, vacation, everything else, but as far as this law goes, it can be used for your own illness, it can be used for a family member's illness, and can be used to seek treatment if you're a victim of domestic violence or stalking or whatever the other one is. So you want to make sure that it specifies that. As long as you do that and you're offering at least 3 days a year, you should be fine. You probably also need to allow the accrual to be up to 6 days so they can carry it over if they don't use it. I don't know any PTO policies that are, like 3 days a year, so you should be fine. But as long as you do that, I think you're fine. You still have the posting requirement, so you have to get the poster up, and you still have the wage theft notice requirement, so you need to start using the new one. The wage theft notice specifically says sick, but there's 4 options on it, and you would just check the box that says, like, we do something that's a compliance. I don't remember what the language is, but you'll see it. You'll know it. It's pretty straightforward. So if you're currently offering PTO, make sure it's compliant with this. It's 24 hours a year, and it can be used for illness. If you're currently offering sick, you want to do the same thing. Now again, you have to take a look to make sure that it's in compliance with this, because I do have clients that are currently offering sick, but we needed to make some changes to make sure they're compliant. You need to make sure that if you're doing a grant that you're granting at least 3 days a year. You want to make sure if you're doing an accrual that all those other rules come into effect. There's also the issue about part-time. So let me back up to the PTO answer, because if you're offering PTO to your part-time employees, you need to take a look at that and make sure that they'll have at least 3 days. And again, the law unfortunately does not allow you to prorate it like we normally would. So you want to make sure they're going to have at least 24 hours that they can use towards sick over the course of the year. If you're adding sick, this is a new benefit. You don't have to make decisions until July. You do have the two record-keeping requirements right now, but you can start in July, and you have some time to figure out how you want to do it. And this is what we help clients with all the time. So if you need help figuring this out, just pick up the phone and give me a call, and I'm happy to talk you through it.
Okay, good explanation. Marla, did you want to add anything to that?
No, I'll let Linda speak to all the sick pay because she's got it down pat. It is really convoluted, and maybe just to add that do get some help because it is convoluted. And as Linda, I think, did a great job explaining, there's so many twists and turns, especially if you're going to do the accrual.
Oh, yeah, definitely. Perfect. We're going to move on to cell phone reimbursement. Crystal has a question. Instead of cell phone reimbursement, can we have a flat monthly expense pay instead?
Well, I'll give you my answer, then I'm interested in hearing Marla's opinion. I don't see why not. Again, I would make sure that if you're going to do that, you have some sort of statement the employee signs acknowledging that this is to cover all work-related expenses, such as mileage, cell phone, whatever. There are also IRS implications, though, from a taxation standpoint. Like with mileage, as an example, you can have a flat car allowance policy, but if it's a non-accountable plan, then that's taxable. So that would be my other concern, is you might want to check with your CPA to see if that so-called reimbursement, when it's a flat amount and a non-accountable plan, is now a taxable thing to the employee, because you'd want to try to avoid that, obviously. If you're using mileage and they're actually turning in a mileage expense, I drove this many miles on this day, that's an accountable plan, and that's how you can just do a straight reimbursement, and it's not taxable to the employee. Marla, you have an opinion on that?
Yeah, just a comment, really, and great question, whoever asked the question, because candidly, there is no right answer. The Labor Code section makes it very clear that whatever expenses the employee incurs on the employer's behalf, you have to reimburse. And the case even talks about how we really don't know with specificity exactly to the dollar how much was attributed to the employer and how much was attributed to the employee on their use of their cell phone. So I agree with Linda. I think the best way to cover it is to get an agreement. Yes, this is going to cover my expenses, whatever it is. If it's the full amount, if it's a partial, I'm estimating that I use my phone 10% of the time. That's what we do here, by the way, is we have the employees estimate the percentage of use and then take whatever their bill is and pay them that percentage of use. Eventually, because cell phones are still, believe it or not, new in the world of the law will catch up to the technology, and we will probably get some sort of safe harbor like we have with the mileage, where if you pay a certain amount per mile, the law recognizes that's sufficient to reimburse for expense. However, it is very clear that if they can prove that it's more, even though you've paid the safe harbor, then they're entitled to more. If the employee can actually prove what the actual expense is to the dime, if the employer is obligated to pay it. Now, the good news is there's not the kind of waiting time penalties, liquidated damages penalties with expense reimbursement. We don't see very much litigation on expense reimbursement other than just cut me a check for something. It's only when the employer says, I'm not reimbursing anything, where we really see the claims come.
Okay, great, ladies. And then Judy's wondering, well, now if we're doing this with cell phones, is this going to affect other areas, such as employees required to use their own personal tools for work?
Yes.
It will.
With a caveat, there are certain industries, for example, in the automotive industry, if you are in the automotive industry and you're a repair person, you can be required to use your own tools. There are some industries under some of the wage orders that employers are allowed to require the employee to bring their own tools, but there are others where they're not. And if you're doing that, then yes, you would have to reimburse the employee for that, just like uniforms and the like. So you'd have to look at each industry and each wage order independently.
Okay, good. And Terry just wants a clarification. On 30 days a year, is that 8 hours a day? And I'm assuming that's calculating. Oh.
Yeah, wouldn't that be great if the law actually explained that to us? It doesn't. And while Marla was talking, I actually pulled up the law and scanned it again real quickly to see if there was a definition, because I saw a few people had that question, and it doesn't say how to define a day here. They define the sick pay, 3 days or 24 hours, but I don't see any place where it defines the 30 days per year. So sorry, I don't have an answer for you. If I had to guess, I would say any day that they work any time at all is going to count as a day. Okay. But simply my guess and interpretation.
Okay, great. Sandra's wondering, they implemented on January 1st a lump sum of 3 days, and I would say this is for the sick pay. We never had 6 days in the past, but my question is, if someone starts in April, so on August 1st they would also get 3 days, question mark?
No, I'm not sure I'm fully understanding, but let me just sort of reiterate what the rule is and see if this answers your question. If not, you can reach out to me. So there's a requirement that the person gets 24 hours of sick pay each year. That can be done Jan 1 of every year. It can be done on a rolling 12-month period or whatever. Now, if you're saying for somebody that's hired at some point during the year, how do you handle that? Yeah, they've got to have it every 12 months. And so you can define it as a rolling 12-month period tied to their hire date if that's what you want to do. I would advise my clients to do a calendar year basis. I just think it's easier to track. And if somebody's hired like at some point during the year, we're going to go ahead and grant that to them. We may do it on a prorated basis because we know that if it's at least 3 days over that 12-month period, if they get another 3 days like Jan 1, they'll be in compliance. So I think they're going to be fine doing that.
It's certainly an area where we may see some abuse. To the person who raised the question's point, so let's make it worse than July. Let's say it's November. You have somebody hired in November and you've given them 3 sick days. Oh, great, Christmas holidays, Hanukkah are here. I'm going to be sick for 3 days in December, and guess what? In January I've got 3 more. It's definitely an area where you might see abuse, but it is, to Linda's point, I think much easier to do the lump sum and take that risk, knowing that you can, discipline if you think that it is being abused and it's not truly being used for the true purpose. Then have the risk of improperly accruing.
Okay, good advice. Desiree has a question. If the company has a PTO policy for full-time employees, can the company maintain that policy and then create a separate policy, sick pay policy for part-time employees only?
Yeah, absolutely, and that's what I'm doing with one of my clients. The sick pay for full-time people, I think, is, again, pretty easy, especially if you're going to do a lump sum. We changed theirs because it was on accrual, so we're just doing the grant January 1st. We in fact just did this, did the grant January 1st, and that's how we're going to handle full-time people. The part-time people, we're selling it as like, hey, great news, you get a new benefit starting in July, but we didn't even give them details yet because we're still working with the payroll provider to figure out how they're going to do the accrual. We don't want to give them a grant of 3 days because many of these guys, they would never even get to that limit because they're working literally like 5 hours a week or whatever, or just every once in a while they'll work some hours. So we're probably going to do it on an accrual basis, but we're still, again, trying to figure out the logistics of that. So you can treat, we'll say, those classes differently. That's fine. Again, as long as you're not doing it on a discriminatory basis, you're fine. But you can have one policy for your full-time and one policy for your part-time.
Okay, great. And Jai wants to know, can or should employers impose a 90-day use requirement on existing employees, not just new hires?
Yeah, I don't see anything in the law that prohibits that. Marla, do you know of anything? I don't see anything that prohibits that. It specifically says that people have to approve from day one and that there can be a 90-day waiting period for new hires. So I don't see why it wouldn't apply if you're just implementing that policy now. I don't see why it would be a problem waiting. Do you have any rebuttal?
I don't. Yeah, I don't either.
Okay. We're going to go, yes, do it.
Okay, good. And then Jane just wants to clarify that sick pay starts on July 1st, 2015, and the notice we had as of January 1st, 2015. Is that correct?
It is. So the two things that went into effect already are the poster and the wage theft notice. So you just have to amend that, and those are the two things we're sending out in the follow-up email to this webinar. So if you're on the webinar today, if you show up today, you're going to get those two things in an email probably tomorrow from us or later today. So look for that. Make sure you're using those now. The wage theft notice you can put into place, but right now you're not even offering, if you're not offering sick, you'll have to see which of the boxes apply, or you might have to add something to your form to amend it to say currently not offering this. But if you're already offering sick pay, start using the new form so it specifies to the employee how their sick pay is actually being calculated.
Okay, good. And Laura's wondering, can I offer more sick hours to a certain group of employees?
Yeah, again, if it's not done on a discriminatory basis, I don't see why not. Like I was saying a second ago, I think if you have full-time employees and you have one grant, or you do it one way and then part-time you do another, that's fine. It's not uncommon, to do it based on length of service or different job types or whatever. So I think you can set it up as long as on a non-discriminatory basis and you meet the minimum requirements. I think you're fine.
Okay, great. And Melody wants to know, does the NLRB provide guidance on just how much non-work related email should be allowed?
This is a Marla question.
I'm sorry, Julie, can you repeat it?
Does the NLRB provide guidance on just how much non-work related email should be allowed?
No, not yet. This is brand new. I think this was in December, this ruling. And candidly, it kind of sent shockwaves. That's why everyone is saying it's likely to be appealed. And again, it was decided on a 3-2 basis. I mean, it's a great question because it raises the issue of, well, when do we have to let them do this? We don't want employees lingering on site, as we all know, because then there's always potential claims that they were working. So does this mean we allow them to use it during lunchtime and their breaks? Because they might be there and that's it? Do we make our policies regarding not lingering and leaving the premises while not working stronger? And we don't have any guidance there yet.
Okay. Unfortunately, we are out of time today, ladies. We have a ton of questions left, and what we'd like to do, I think, Linda, is maybe we can go through and I can send these questions to you both, and maybe there are some that we can answer. Otherwise, for all those that are listening still awaiting some answers to your question, you've got Linda and Marla's email addresses in the handouts, and you'll also, as Linda mentioned, get an email tomorrow. So in there, I've definitely add links in for you to be able to email them directly. And Linda, would you like to wrap up for us today on the next webinar, and anything else that you might want to announce?
Yeah, absolutely. So you can see on the screen my email address and Marla's email address. So again, feel free to reach out to us. with any specific questions we didn't get to today, our apologies. We had a ton of people on here, so for that we are very thankful and grateful for you joining us. Our next webinar is going to be on workers' comp, and we're really excited because we have 3 guest speakers. In fact, Marla and I love these because they do all the heavy lifting. So I will not even be here next month because I'm at a conference. Marla will be here, and she will be talking about Section 132A claims, which is really important. You don't ever want to get tagged with one of those. We actually have 2 insurance brokers, and we have a great woman that I've known for a number of years who does claims, like her background is in claims administration on the workers' comp side. So we're still putting together the actual content. So we might even send you a follow-up question on what specifically you might want to know about workers' comp, because there are so many rules out there. Workers' comp, what to do in the case of an injury, how is your experience modification calculated, because that just hits your bottom line. So it's great for HR folks and business owners to understand that, what you can do about it to lower that. I think those are the type of topics we're going to discuss, and I'm really looking forward to, I guess in my case, hearing the recording afterwards.
And hopefully we won't have any technical issues, Linda. You will be able to hear it.
Exactly.
Spoken like the true webinar moderator that I am. So, anyway, and again, Marla, did you want to add any comments at the end here? No? Okay, well, great. Again, we want to thank all of you for attending. It was one of our largest, and we appreciate you taking the time and learning about the new laws for the new year. On behalf of Linda Duffy with Ethos Human Capital Solutions and Marla Merhab Robinson with Merhab Robinson, Jackson, and Clarkson, I'd like to thank all of you for joining us. We certainly appreciate your time and hope you have a great rest of the day. Thank you.